Good morning, everyone. I would like to welcome the officials of the Ministry of Finance and the Office of Procurement Regulations to this public inquiry. And the objectives, I must say, of this inquiry are to assess the progress achieved by the Office of Procurement Regulations in implementing the recommendations of the committee, to examine the factors and circumstances that are hindering the successful implementation of the Act, and to obtain further insights into the plans, strategies, and initiatives that are being pursued across the public sector towards the full proclamation of the Procurement Act and regulations. Now, this issue of public procurement is one that has generated a lot of interest. Over the last couple of years, I have myself collected a number of newspaper clippings. We've had press releases from ministers. We've had talk shows, because this is an extremely sensitive issue. When we talk about public procurement, we're talking about accountability, integrity, transparency, and value for money. We are well aware that all of the resources that you need to execute government's policies, all of the resources, all of the personnel do not reside within the bosom of the government. And it is therefore imperative, and it's nothing that is unusual to us, that we must call on outside agencies to fulfill these needs of the government in implementing its policies. In doing so, whenever we have to hire someone, we're talking about how government's money is to be spent. And when we talk about government's money, it's really taxpayers' money. And therefore, taxpayers across the board have an acute interest in how things are procured. Unfortunately, depending on if you sit on the northern side or the southern side of the well, thoughts might change over time. So what at one time may be normal and acceptable, when you go to the other side of the well in the Parliament chamber, and we know all the stories, things aren't always viewed. As you change your position, you get a different view and you espouse a different view. The public, always caught in the middle, are looking on, the members of the public, and they have a keen interest in things being done right. And that's why we've called you together this morning to assist in this very, very, very important exercise, to make sure that we get it right. Because the future of our country, our citizens, depend on our getting it right. Good governance. The officials appearing before us today are from the Office of Procurement Regulator, Mr. Munilal Lalchan, the chairman, and he is the procurement regulator. Ms. Delreen Liverpool-Young, the corporate secretary. Ms. Marissa De La Rosa, she's the head of the procurement capacity development, and Ms. Lindy Ann Mitchell, who is the head of legal. And we have also the officials of the Ministry of Finance, Ms. Jennifer Lutchman, who is the permanent secretary, Mr. Ryan Maharaj, the director, agro-based manufacturing and servicing sector, and Mr. Jonathan Suhorn, senior state counsel. I will now invite these persons, beginning with the Office of the Procurement Regulator, to introduce themselves.
Thank you very much, Chair. And a pleasant good morning to the viewing and listening audience. And again, we want to express our appreciation to the committee for inviting us this morning to share with the committee. My name is Munila Lalchan. I'm the chairman and procurement regulator. And I'll ask the different members of my team in turn to introduce themselves and briefly give a description of what they involve in the office in doing. So Marissa.
Good morning and thank you, Chair. I am Marisa Shari Delarosa, Head of Procurement Capacity Development at OPR, and my responsibilities include basically awareness of public procurement retention and disposal activities to public bodies, as well as sensitizing public bodies, contractors and suppliers to public procurement, retention and disposal of public property.
Good morning, members. Lindy Ann Mitchell, Head Legal. I am basically responsible for advising the office on all legal matters as it relates to procurement, disposal of public property.
Good morning, everyone. My name is Delreen Liverpool-Young. I'm the Corporate Secretary at the Office of Procurement Regulation. I am responsible for providing legal advice to the board, as well as assisting the procurement regulator with his operational functions.
Officials of the Ministry of Finance, you are invited now. Introduce yourselves.
Good morning, Chairman. I am Jennifer Lachman, Permanent Secretary, Ministry of Finance. And I would ask the other members of the Ministry of Finance to introduce themselves.
Good morning, Chairman. Jonathan Suhan, Senior State Counsel.
Good morning, Chairman. Ryan Maharaj, Acting Director, Agro-Based Manufacturing and Services Sector.
And also, thank you very much. Also part of this inquiry are our members of our viewing and listening audience, and we welcome them to the 13th meeting of the Joint Select Committee on Finance and Legal Affairs. Members of the listening and viewing audience are invited to post or send their comments via the Parliament's various social media platforms, Facebook page, ParlView, the Parliament's YouTube channel, and Twitter. I would just like to remind you that you are to mute your devices, and when you speak, you put them on. And we will begin by asking the heads of the two entities before us to make brief opening remarks, no more than 2 minutes, please.
Once again, thank you very much, Chair. And we would have been requested by the committee to give certain answers to particular questions that were posed to the Office of Procurement Regulation. We would have so done, and we hope that it would give sufficient insight to engender some fruitful discussions this morning in terms of our responses. So with that said, we are ready and prepared to answer any questions emanating from those submissions that we would have sent previously. Thank you very much.
Thank you, Mr. Lachan. Ms. Lachman?
Good morning again, Chair and members. The Ministry of Finance is the line ministry of the Office of Procurement Regulation, the OPR. We are mindful of the provisions of the Act that governs its operations, which state that the office is not subject to the direction or control of any other person or authority in the performance of its function, but shall be accountable to Parliament. We want to thank you for inviting us here today. And of course, we give our commitment to provide any information that you may require us. Thanks, Chair.
Thank you very much. The hearing will proceed. Remember, please, to direct any comments and so through the chair. So we will begin with the Office of Procurement Regulation. For the benefit of the public, can you briefly explain the main advantages of the new proposed public procurement system? And then let us know where we are in terms of operationalization of the new public procurement system, please.
Thank you very much, Chair. I'll probably start by giving an example of what would have happened in some studies that were done in terms of the Organization for Economic Cooperation and Development in 2014. And they would have suggested one of the areas that is most likely to attract corruption is in government circles in terms of just the volume and the amount of transactions that takes place. Another study was done by the European Commission, and they suggested, sometimes we beat up ourselves in Trinidad and say we're so corrupt, but in the European countries where there was a leakage of over 120 billion euros on an annual basis, and the main reason that they put forward for those leakages is because of poor management. Over 48.5% resulted in poor management of the structures associated with procurement and disposal activities. So it gives you an idea as to what are some of the prizes, and what both studies suggest is that between 10 and 30% of the amount of money that is lost is due to corruption based on the amount of money that is spent. And we normally put some back of the envelope calculation. So in Trinidad, if we suggest that 50% of our budget, and this includes all the state enterprises like the big companies like Heritage, Caribbean Airlines, national gas companies, and so on, and we pull those together and we pull those figures, and we estimate that about $26 billion is spent. If we can save 20%, that's between the 10 and 30%, you're looking at a savings of about $5.2 billion per year. And these are figures that we can potentially save. Of course, the figures could be challenged in terms of whether or not we're accurate, but is the price that we're going after. Think about what we can do for this country in terms of the health sector, the roads, and the infrastructure that you can benefit from. So herein lies the reason why over a number of years, there has been a cry for the procurement to be done in a particular way. And the Procurement Act came into being in 2015. And since then, we have been putting the necessary structures in place, but the board was only appointed in 2018. And since the board was appointed, what we did was to look at Section 13 of the Act that gives us what our mandate's supposed to be. And based on Section 13, we broke up the organization into discrete areas that could deal with issues associated with operationalization of the Act. And for example, we would have had over 325 public consultation and sessions with public bodies, from the very high public organization to the very low in terms of NGOs. Insofar as, for example, a number of NGOs fall under the Act because they receive public money. And we would have had those sessions for sporting organizations and so on. So there is a prize to be had by the new legislation. In order to really go after that prize, we have to get the public bodies in a state of readiness. So a substantial amount of our time would have been spent on the readiness of public bodies. And I'm very happy to say today that a number of public bodies has taken this on board. Just for example, we would have recently had meetings with the Ministry of Health and all their regional health authorities. Coming out of that meeting, we would have had a discussion in terms of their handbooks and guidelines. The Eastern Regional Health Authorities actually spearheading that exercise. We would have set up a database. Previously, every public body was responsible for their own database of pre-qualified contractors. And you would have heard a number of horror stories about persons not getting on the database and they had to pay under the table to get on the database and so on. We heard from one particular individual who said that he would have applied over 39 times, spent $43,000 to get pre-qualified, and still to date, he has not been pre-qualified. So you have one database now under regulations that all public bodies have to use to get their contractors and suppliers. So there is one source of the truth. And literally, you don't have to pay to get on this database. It's 24/7. I'm happy to say that the first ministry that actually pre-qualified contractors and suppliers on our database was the Ministry of Works and Transport. We have just completed a session with the PTSC in overviewing their handbooks and guidelines so that they can go fully operationalized. We've just last Friday had a meeting with TNTech And I want to say that TNTech and WASA are way ahead of the rest of the organizations. We had a meeting with over 300 employees of the Trinidad and Tobago Electricity Commission to go through the requirements of the Act. This just gives you an idea of what takes place in the background. And I'm happy to say that we have so far 141 named procurement officers. We are in the middle of some training sessions that has over 300 participants over the last 3 months to deal with specific issues as it relates to procurement and disposal activities. Now I can go on and on. We would have established over 46 handbooks and guidelines that guides public bodies. And out of that, we would have circulated and sent to all public bodies to tell us, do you want to accept our handbooks and guidelines, or would you want to prepare your own one? So far, we have had very good responses where most of the public bodies would have come to us and said, we will accept yours with minor tweaks being editorial. So for example, some of the organization would have said, we will change the name in the handbooks and guidelines, and that's all the changes. So by and large, we believe there is a critical mass that is now in place across public bodies to give effect to the Public Procurement and Disposal of Public Property Act. And we believe that we're in a good position to get this act fully proclaimed, barring the minor issues of getting the regulations associated with 57A in terms of real property, the guidelines in terms of 7.5 in the Act that deals with the exempted services, and the operationalization of the review board. Apart from those three areas, we believe that we're in a good position to get the Act fully proclaimed. And I'll stop there because I don't want to go into too many details again, but if there are any questions coming out of what I just said, I'll be happy to, or my team will be happy to answer those questions.
Thank you so much. We do have some other questions for you. Especially with regard to the judiciary and their comments. So, Member Dian Singh.
Yes, ma'am. Good morning.
The issues raised by the judiciary?
Yes, good morning, Chair. Am I being heard? Yes?
Yes, we are hearing you.
Good morning to all. Good
And,
morning.
Yeah, we've given the floor to you.
Yes. Thank you for your very in-depth submission. I don't think anyone on this committee will want to see corruption, especially white-collar corruption, go unaccounted for. So I think we are all on the same page and have the same purposes. However, rushing to full operationalization without the chairman taking into consideration the views of the judiciary, I think is something that we have to guard against. If I could ask some questions about what the judiciary and the AGLA's response was about. If I could ask the chairman to look at the issue of what is public money and what is a public body. Is it that the law envisages that between the definitions of a public body and public money are seen indeed distributed by a public body to a person? Does it mean that every recipient as an individual of a grant, a pension, a flood grant, whatever grant that a person, an individual gets, hundreds of thousands of persons, are they subjected to this act? And is that desirable? And was that the purpose of the legislation? Because then I have some follow-up questions depending on the answer.
Thank you very much for the question, and through you, Chair. A strict interpretation of the legislation would lead to one to believe that that is in fact what the legislation says, because it does says that the money given to a person. So what we also zeroed in on is the fact that we are dealing with procurement. And when we met with a number of the NGOs, some of these subventions, most of the money goes towards paying for salaries of these persons that give themselves to the NGOs' work. And therefore, our interpretations is to zero in on the procurement aspect of what takes place with the state funding, and not to go after those who get subventions for flood reliefs and so on. We don't believe that was the intention. And I'll give you another example. We recently my team met with the sports company of Trinidad and Tobago, and about 15 organizations that benefit from public money to run their organizations. And we're speaking about millions of dollars given to these sporting organizations. And coming out of that meeting, the sports company decided that they are going to work with these organizations that benefit from public money as defined, but assist in the procurement aspect of things like when they go on visits overseas in terms of airlines, hotel accommodations, and so on. So there seem to be a differentiating between what leads to procurement activities using public monies, as opposed to just grants coming and dealing with how you work with the NGOs and so on. So there's where we see the distinction for using public money. We don't believe that there is an attempt to go after persons who benefit from flood grant, agricultural grants, and so on during flooding.
Chair, that may not be the intention of the OPR, but we have to go on what the Act says. And I can tell you in the case of the Ministry of Health, we give subventions to NGOs and they use it to purchase equipment, not just to pay salaries. So I think we need to have a distinction between what Chairman Rauchan is saying of what his interpretation is versus what the Act says. Because you see, what is going to happen when we dovetail this with the challenge proceedings? And under the challenge proceedings, you have 128 days appeal tribunal. You can go to the High Court, the Appeal Court, the Privy Council. And whilst that is going on, you also have FOIA requests, judicial review, contract challenges. And this is what the judiciary is saying, that they are not prepared or resourced to furnish all of this. And what is going to happen is that busybodies, and there's a famous case when JR first came out that spoke about busybodies, that these busybodies will just deliberately stymie the system, and the very individuals we would like to be helping will be unfortunately caught up in this, whilst the courts determine what is a public body, what is distributed by a public body to a person, and what is public money. So I think whilst Mr. Lauchan has excellent intentions, I would place some emphasis on what the judiciary is saying. And these interpretations and these busybodies going for challenge proceedings, FOIAs, GR, contract challenges, all the way to the Privy Council. I don't think this is the intention. So we need some comfort of whether the Act needs to be amended on this one issue alone, and I have others to talk about.
If I may, Chair, in respect of the challenge proceedings under the Act, it is very restrictive. So it's not an open-ended amount of challenges that could be brought under the Act. And it speaks to very specific areas for challenges to be made in terms of time periods, for example, during and pre-selection, pre-qualification, and solicitation. During that period, even before the contract is awarded. And then within 7 days of a contract or a framework agreement being awarded, if there are no challenge proceedings. And then the third time that you could have a challenge proceedings is within a stipulated standstill period of between 10 and 15 days. So if a contract is, let's say, 20 days in already awarded, after that 7-day period, there is no room for challenge, but there is a room for an investigation. So the challenge proceeding is very restricted, and that was made clear in our response to the Honorable Attorney General when those questions were raised in terms of the challenge proceeding. So I just wanted to make sure that we understand that it is not every and anything that could be challenged under the Act.
Chair, I really hear what Mr. Lalton is saying. I am speaking in my capacity now as Minister of Health. I am currently procuring some supplies that are not available in Trinidad to do open heart surgery procedure on a person lying down in one of my hospitals. 7 days is the difference between life and death. And what the Act, so when I marry those challenge proceedings, 7 days may not sound much in purchasing a paperclip. But in the Ministry of Health, where time is of the essence, as in this case I have now, because it's a very rare operation we are doing, and we have to bring in a doctor from abroad, we have to procure that service, he has to come with his consumables, and then the Act does not say, nor the regulations, what is an emergency? What is a medical emergency? So from a practitioner in health, I am concerned that even 7 days for challenge proceedings to save this woman's life lying down at North Central RHA could lead to death. Because if I am trying to procure this person's services and the consumables to do this operation, and another entity who wishes to also do the operation can delay this by 7 days. So I'm just asking Mr. Lalchan to clarify that for me, please, and for members of the public, because members of the public who depend on the public healthcare system, this is your life I'm speaking about now.
Thank you very much again, member, and through you, Chair. I'm glad that actually was raised, because in my introduction, I mentioned the whole issue of 7.5 under the Act. And based on the amendment to the Act in 2020, and I quote, "The Act shall not apply to the following services provided to public bodies or state-controlled enterprises: medical emergencies or other scheduled medical services." And I also mentioned that the minister shall submit to the office annual guidelines which outlines the circumstances under which exempt services in subsection 6 may be procured. So it is an exempt service. It does not fall under the Act, and the minister has to prepare the guidelines to submit to Parliament. So that is well taken care of in the amendment to the Act.
But Mr. Lalchan, could you tell me, for me to get that, what is an emergency? Because the Act, neither the Act nor the regulations define what an emergency is. Or is this something that we have to submit to you as to what is an emergency?
And that, through you, Chair, again, and that's absolutely correct. Remember, I mentioned again, the Minister of Finance is the one who defines those exempt services and what is exempted. And once that goes to the Parliament, then we are guided by those guidelines. So the guidelines has to also have the definition for medical emergencies and exempt services, like what constitute legal services, debt financing and services. So all those still has to be prepared by the Minister of Finance.
Okay, so this will be my last question on this, because I want to give the opportunity to others. So is it that we are saying before the Act is proclaimed that we should clear up these issues?
Through you, Chair, and I would have mentioned 3 areas that we still need clarification on. 1 was the exempt services, 2 was the operationalization of the review board, and 3 was the section 57B or 57A in terms of the disposal of real property. So those were the 3 things that I mentioned in my preamble. So the member is quite right.
And I just want to remind members that what we said earlier in our meeting is that the Attorney General will be with us in the next meeting. And some of these questions might properly be directed to the Attorney General. And also, you know, sometimes in legislation, there are always gray areas. You do not legislate for every single thing. And sometimes what you have to do is use a common sense approach. What is an emergency? And I don't think that there's going to be any great difficulty in determining an emergency in the Ministry of Health, that we would be, you know, spending time looking at whether the procurement applies and, you know, the length of time. I think that people would be well competent within the area of competence to determine when you need to move on something very quickly. So be assured, Member Dialsing.
Just my last intervention. That may sound good, but when you sit in the chair of a Minister of Health and you get these weird requests, I have a FOIA request now asking me what is a repeat prescription. It is amazing what lawyers come up with to throw at you when you sit in this chair. I'm just throwing that out. Thank you.
I can well understand your difficulty that, of course, you know, there are instances where people make work when they know very well that some of the claims cannot succeed. So that's the reality of life. But we deal in, you know, to be practical in a number of instances. And I don't think you need to be fearful, Member Dialsing, that things will proceed because you have a number of people, they say common sense isn't so common, it will prevail. And we'll get where we want to go. Do you have any further questions, Member Dialsing, for the Office of Procurement Regulator? Let us proceed.
So, Madam Chair, if I'm allowed to make an intervention,
yes,
I just want to shift the conversation slightly. We accept that the procurement procedure is heavily people involved because we're dealing with goods and services, and we're dealing with people. And so I want to shift the conversation to the website and the web page capabilities. And I saw in the submission that the OPR said that they are seeking to implement the help desk by December 2022. I just want to find one for the sake of the public. We are a few days away from December. Where are we with the implementation of the help desk? And are there additional resources required to operate the help desk? And then I'll continue after with follow-up if they depend on the answers.
Thank you very much. Through you, Chair. Thank you very much for the question. The help desk has to do with a specific help desk. We have a number of help desks that we have created already in the OPR. For example, I mentioned the whole issue of the depository and the pre-qualification list. That help desk is already operationalized. We have responded to over 600 queries in terms of that particular help desk. The help desk in terms of the handbooks and guidelines is fully operationalized. And we have responded to a number of queries there. The help desk in terms of general matters associated with day-to-day activities, we have responded to over 1,000 queries there. And in terms of the help desk has to do with the administrative review secretariat that we are putting in place, and also the complaints. And those will only come into being, as the honorable member would have mentioned, the Minister of Health, in terms of hearing procedures and so on. So when persons want assistance in terms of how they fill out those forms associated with these hearing proceedings, that's the help desk that we are putting together. So there are a number of help desks already in operations that would, and those that will come into being that we mentioned in December has to do with the full operationalization arising out of the full proclamation.
Okay. And as it relates to your webpage, how is the webpage being promoted to the public?
We, again, through you, Chair, we have a boosting session that we normally do through the Corporate Communications Department. And for a very small fee, for example, you can actually boost through the various social medias for $10 US. And we have seen an uplift. For example, we have done some boosting and it went from about 500 views to over 12,000 views. So far, we do that regular boosting through the website, and we have gotten good traction so far.
But through you, Madam Chair, if I am a regular citizen, what is the OPR to me? How do you promote that to me, for me as a regular citizen, to see the benefits of the OPR to my life?
Thank you very much. Again, through you, Chair. This is where what in our public consultation, we have shown where the potential savings could do for this country. But even further than that, here is an opportunity for the average contractors to come onto the website and be pre-qualified. So you have the moms and pops, you have the small operators like the electrician, the plumber, persons who do landscaping and so on. They can literally come onto the website and be pre-qualified and be seen by all the public bodies. So if you want, for example, an electrician in the Mayaro area, you have a list because we are asking people to come and pre-qualify by regional corporation and by the Tobago House of Assembly. So there are 4 categories. So you have regional corporation for geographic location. Right. You have the Tobago House of Assembly, you have CARICOM, and you have international. And so you can pre-qualify in any one of those areas. You're looking for a plumber or electrician, you can zero in on your fence-side community to see who are the ones qualified there and give them an opportunity. In that way, you have sustainable development as it relates to the growth of those suppliers and contractors. So that's a major help that will be given to the small and medium-sized contractors and suppliers. All that is catered for on our depository.
So if I'm to follow you, Mr. Lanchal, through you, Madam Chair, this not only benefits the government per se, but it also redounds to the regular citizen who can view contractors who are registered, for lack of a better word, but you are better able to find it. So it's more than just for procurement purposes. It could also be seen as a directory to find certified, qualified contractors in a specific field.
And through you, Chair, that's exactly what it is. The other advantage of the depository is that it puts everybody on an equal playing field. So, for example, one public body do not use a different yardstick to pre-qualify supplier and contractors. So it's being done on an even keel so that you don't have, there are no surprises when you come onto the depository. And the depository works in such a way that not every 3 years you'll have to be pre-qualified. Once you keep your documentation up to date, you remain on the depository. Now, if you misbehave and provide good services and so on, you can be made ineligible and be taken off the list of pre-qualified contractors for a certain specific period of time. So there is a level of making sure that you have the proper performance and not everything goes for doing business with the public body. The other advantage is that you are now required to demonstrate that you have made sure that you are in compliance with all the statutory obligations of paying your taxes, of your NIS, of your VAT. All those are requirements to be pre-qualified. So you benefiting from public money, taxpayers' money, you have to discharge your obligations under the Act. And Section 29 provides all that. So those are prerequisites from being pre-qualified on the database.
Okay. But Madam
So
Chair,
Go ahead.
if I could continue, I'm asking if the OPR wants to be more focused in terms of marketing what they do to the population, because when you hear about the OPR, you just think about trying to treat with corruption and so on, and making sure that we don't have overspending for contracts and that kind of thing. What I'm hearing this morning in addition is that the OPR has the ability to do much more than just that. And so I'm asking if there is a thought by the OPR to do more marketing, to put themselves out there so that the population knows that the Office of Procurement Regulation is more than just trying to stamp out white collar crime.
Through you, Chair, thank you very much, member, again. We do have an extensive public relations campaign, and it goes right down to the schools, actually. We have a number, we just recently completed art and craft competition among the school for different levels of the age group, and that was pretty successful. We are working with the Ministry of Education to have a school-based program to make sure, because one of the things we looked at is that if we have to change the society in terms of what we do, it has to start at the school level. So we have an extensive program. You will soon see billboards going up in different areas. We have already completed our radio ads and our television ads. We have been holding back on it actually for the full proclamation. Once we have the full proclamation, we have a timeline already set up to roll out our public information campaign. And that's coming very soon. And you will, I think the country will be proud of it. What we wanted to look at is to make sure that coming out of this legislation, we leave a legacy for the next generation. I'm glad the chairperson would have mentioned that whole issue of leaving a legacy. Because really, when you look at our vision, is to be the catalyst for transformation, using best practice in terms of proclamation, purchasing and disposal of state assets. So if we can use that as a catalyst to change the society, that's where I believe, member, you were heading, and that's exactly where our board is. That's where our head is right now. So procurement.
Thank you, Mr.
So Madam Chair, my final submission for now is in terms of the whistleblower engagement and protection. You said that you made further reference to a whistleblowing platform, which is ready to be officially launched. And two questions very quickly. What date has been finalized for the launch of this platform? And what distinction has been made between the whistleblowing and the complaints platform?
Thanks very much. And again, through you, Chair. The date for rollout of the whistleblowing, we have done all our media ads and so on, is exactly 1 month after the full proclamation, because without full proclamation, it doesn't make sense going out with the ad. So we have completed the advertisements. We have established 1 month after full proclamation, full steam ahead. And sorry, the other question, member, I missed it.
What distinction has been made between the whistleblowing and the complaints platform? Or is there a distinction?
There is definitely a distinction, through you, Chair. The complaints has to do with any request for investigations and so on that may come out through the office. We may look at a newspaper ad or a newspaper report where it says that there is alleged corruption somewhere. We can initiate investigations and so on. If you have a complaint, you can come to the office and make a complaint physically if you want to be known who is making the complaint, you can do it physically. So you walk into the office, you make that complaint, we have a complaints officer already on board. Now, if you want to remain anonymous, you come to the whistleblowing facility. And that whistleblowing facility has different methods of which you can make the complaint, either by email. It has actually been tested for the last year. And it is an organization outside of Trinidad. So if there is any fear that person's name and so on will be known, there is literally a Chinese wall. So we don't know who calls, when they call, and what they say. All is fed back to us is a summary of the information, and then that is fed through the legal department to the audit and investigation department. We have a fully trained staff to do the audit and investigations already on board.
So are you saying, therefore, that somebody comes and, drops a bomb, that you have people who are competent enough to know whether this is mischief, whether it is sour grapes, because you didn't get the contract, and and these allegations are being made against the person who was successful. So do you have the competence within the institution to be able to deal with that rather than launch a whole big investigation with something that can be easily dismissed?
So thanks very much, Chair. And one of the things that we would have done is actually engage free of charge, and we want to again say thanks very much to the head of the judiciary. We had 10 judges from the judiciary actually trained us in those areas. For example, evidence gathering, what is permissible, what is hearsay, and all these different things. We also had 3 of the senior judges from the Caribbean Court of Justice trained us. So 13 judges of eminent qualification. So and that training was extended to our members of the board and also our employees. We have also developed forms that you can fill out if you want to make a complaint for investigation. There is a form that you fill out with the different information. Based on that information, that is now filtered through to our legal team, who then looks at it. So there is a filter by the legal team who decides whether or not it has veracity. Does it make good sense to continue? And if that is the case, then it's handed over to the audit and investigation team. And then at the board level, we have an investigation oversight committee. Post the investigation, they then look at the evidence and what the responses were in terms of the report after the accused person has been given an opportunity to respond. So all that is already built out in the...
Thank you so much. Mr. Lachan, I must say that you sounding as though you armed and well prepared, you're straining at the bit, and you're just waiting for all systems to go to say, ready, set, go. But I want to ask you though, if before I go to Mr. Scotland, whether, of course, you're aware of concerns raised by the judiciary, and do you think that they fall outside of the remit or sphere of influence, and also of your influence? And what are the most critical concerns raised by the judiciary that must be urgently addressed? Because you've been meeting with them, you've received training from them, and they have some concerns. So how do you respond?
Thank you very much. So there are 3 areas that we have broken down the judiciary letter in. The first area is what we would have responded to the Honorable Attorney General. So there are areas that was raised, there were some concerns, and we addressed those concerns in terms of how we get towards dealing with those. The second area...
Excuse me, before you go on to the second area, would you elaborate? Instead of saying there are areas, what were those areas? Let's know.
Right. For example, there were some issues raised about the evidence and whether or not how we gather those evidence, and we have unfettered powers to go in and request information and so on. We can only do that. The first port of call is to ask the public body to hand over documents in terms of any case that we are investigating. If they fail to do that, it's not that we go in with a big stick and say, well, you have to give us that information because the law says so. No, we have to go to a judge in chambers and get that court order to actually get that information. So the first protocol is voluntarily, they will bring the information before us if we ask for it. Secondly, if we fail there, we go to a judge in chamber. So there is protection in the legislation to prevent an abuse of power by the OPR. So that's one of the examples I can recall offhand. We would have listed all the others area that we responded to in the letter that we responded to the Attorney General, and that formed part of the appendices that we would have submitted to the committee.
What was the most critical concern, you say?
I think the most critical one is the amount of potential complaints that we'll be getting that will have to be going through the court. And that is, from our point of view, it's an uncertainty. Because one of the things that we can't see is through a crystal ball and say we'll have 10, 15, 20, or 100. Of course, in the initial stages, we expect them to come to us, but there is a safeguard in terms of you have to come to the OPR. You're heard at the OPR. If you are dissatisfied, then you go to the review board. And if you're dissatisfied at that stage, then you go to the court. So there is, based on the amendment to the Act, I believe 2016 or 2017, the review board was established just for that reason, so that you protect the amount that is filtering ultimately to the judiciary. And that we believe was the main area that the judiciary said that it's going to create some bottlenecks and issues associated with those hearing proceedings.
What is your view of a total re-examination of this Public Procurement Act, along with a period of further stakeholder consultation?
In terms of, Chair, the stakeholder consultation, we believe that we have had sufficient stakeholder consultation across the board over literally hundreds, over 325, as I mentioned, at different levels. We would have had consultations in Port of Spain, San Fernando, and Tobago extensively in the initial stages when we took up, and that helped us to develop the regulations and so on. That was the main reason. And coming out of that also, we would have made recommendations for amendments to the Act, coming out of those same consultation. So we don't believe that we need further consultation. What we're suggesting is that we need to get the Act proclaimed, see how it works, and then if there are requirements for amendment over a period of time, we will pull all that information together and then suggest through the Ministry of Finance the relevant amendments that we will require to make sure it works. But without giving it an opportunity to work, it's difficult to say that it would not work. And the level of criticisms that continues to come through may, whether or not it is warranted, because one of the members would have asked about corruption and putting people behind bars. Success for the OPR and the board is not about how many people go behind bars or is charged under the Act. It's how many people actually is in compliance with the Act. Because once you infringe and you have court cases and so on, there's a whole set of public money going down the drain again. So if you have people complying with the Act, is what we consider to be success. Give it a try, let's see how it works, and then we take it from there.
Madam Chair, just before you go to members of Scotland, I don't want to ask one brief question because Chairman Lauchon raised the issue about training by the judiciary, and he mentioned rules of evidence. Is it that the OPR will be using the same rules of evidence that a court uses in terms of its weight and admissibility? Will you be doing that?
All right, so I've been talking, thanks very much through you, Chair. I will defer this one to my head of legal, Lindy Ann Mitchell, who can give some further guidance there. So Lindy?
Hi, good day, Chairman and members. The standard that we would be applying is based on a balance of probabilities and the evidence in accordance with the regulations under the challenge proceedings. It would not be adhering to the strict evidence as applied to the court. So the evidence rules as applied in the court system. So it will be much more of an informal approach in terms of the challenge proceedings and the conduct of those proceedings.
Thank you.
Madam Chair,
Member Scotland, sorry.
Thank you, Madam Chair. Madam Chair, through you, I have heard the Office of the Procurement saying that the Office of the Procurement Regulations saying that let us try the act in its current form. I want to make sure I'm not and see how it works. Can I get agreement from the office that this act applies or touches and concerns several stakeholders? Can we get agreement on that?
Yes, through you, Chair, we agree that it does, and the definition for public body is very wide.
And inclusive in the several stakeholders is the judiciary, correct?
That is correct. If I recall, the third item on the definition has to speak to the judiciary after the office of the president, the parliament, and it speaks to the judiciary.
And you agree with me, sir, that the judiciary would have a serious and critical role in the implementation and operationalization of this act. It will not be done in a vacuum. You agree with me? Yes?
I wouldn't go so far as saying the operationalization of the act. They will be required to comply with the act as part of their...
No, hold on. What I mean by operationalization, the act has in it inherent challenges that are directed, that will be directed to the judiciary. There's no ouster clause for challenges that will end up at the judiciary, correct?
Through you, Chair, correct.
Therefore, as it relates to operationalization and challenges, the judiciary would have a critical role to play if and certainly when challenges to certain processes arise. Am I not correct?
Correct. And through you, Chair, again, after it has gone through the OPR, the review board, and then the judiciary.
And whilst that is happening, whilst that is going on, whilst the challenge is going on, whatever the subject of the procurement was, that comes to a standstill, isn't that so?
That is not, through you, Chair, that is not necessarily altogether true, because the office has within its mandate to decide whether or not you're going to suspend or you don't suspend. So those are...
There is, so in a, no, hold
Excuse
on.
me, if I may, Mr. Lalton, I'd like to thank you for remembering that you pass your responses to the chair. And I'd also like to remind Mr. Scotland that he is not being cross-examined here in a courtroom. So you will reframe and rephrase and remember that this is an inquiry and you will pass your questions through me, please.
Madam Chair, I am so reminded, and I will pass the question through you. The question that I want to ask is, you would agree, Madam Chair, through you, of course, that the judiciary has flagged serious areas concern about the legislation in its current form. Yes? Madam Chair? Through you?
Through you, Chair, and I would have mentioned that we have categorized those concerns in 3 areas. One, we would have already responded to the Attorney General, and we await the response from the Attorney General's office to address those concerns. The second area is totally outside our purview at the office, has nothing to do with the office. And the third area, we have identified certain things that we will want to incorporate in our hearing proceedings that the judiciary would have raised to close those loops.
So it means, therefore, that the concerns that have been expressed identified critical issues, and I want to quote here relative to the operationalization of the legislation in its current form. Madam Chair, through you.
Mr. Lalchan?
Yeah, through you, Chair, I think the public record in terms of the information that was provided by the judiciary, and a lot of it, I mentioned before, has to do with assuming certain things would happen upon full proclamation.
So
a lot of it has to do with the level of complaints that you may get, requests for challenges, and all those things, and whether or not the judiciary is fully equipped to deal with it. So that's outside the purview of the OPR and has to do with the readiness of the judiciary to deal with the act. That does not necessarily mean that we need any amendments to the act.
Well, no, well, Madam Chair, my final question on this line is, wouldn't it be more prudent, sir? Wouldn't it be more prudent coming from part of the stakeholder that has the operationalization of the act? Would it not be more prudent to have it fixed, to have it dealt with, these concerns dealt with before proclaiming the act? And as you say, seeing how it goes whilst we operate. Wouldn't that be what we lose around the bend, we don't make up on the stretch? Shouldn't you fix it first? Deal with the concern before you proclaim, instead of proclaiming in light of these serious concerns? That is my question, through you, Chair.
Through you, Chair, and all those concerns that were raised, we would have adequately responded, and we await the response from the Attorney General in terms of our recommendations.
So you are saying to the public, Madam Chair, through you, that there is still a process that is in train, and you are waiting word from the Office of the Honorable Attorney General. Am I not clear? Is that so?
He made it clear, didn't he, Mr. Scotland? I would think.
So therefore, Madam Chair, let me ask another question. You quoted figures from Europe, yes, where you said that procurement legislation saved. Did you quote a country? You just said as the whole of $5 billion. Did you quote a country, or were you referring to Europe on its own?
There were two benchmarks that we used. One, a study that was done by the Organization for Economic Cooperation and Development, where they suggested between 10 and 30% of the publicly funded projects ended up in corrupt practices. The European Commission did a similar study that they mentioned over 120 billion euros are lost every year because of poor management of the public purse.
So my question to you is, through you, Madam Chair, have you done any empirical study that has produced data as it relates to Trinidad and Tobago?
Through you, Chair, that is going to be thing in the future, because the reporting requirements now under the Act, once fully proclaimed, gives you an opportunity to track those statistics. But without the full proclamation, you cannot track the statistics. So we do not have the information, but we will have the information under the reporting requirements of the Act to tell us how much leakages, how much cost overruns, how much variation orders have been going through the system. So all other things that will benefit from the full proclamation of the Act.
No, but Madam Chair, I concede that sometimes it could be me. Did we get an answer? Have you done any empirical study? Do you have any empirical data as it relates to figures and money that can be saved from the Act or from the public procurement legislation in Trinidad and Tobago, or monies lost due to corruption that may be saved? Do you have any data? Yes, Madam Chair, through you, and I don't wish to be cross-examining, but I would like an answer. Through you, please, Madam Chair. Has that been done?
Through you, Chair, no, we have not had any formal information gathering done because the information is not available. But if I were to quote from the Honorable Prime Minister in his address to the Digital Transformation Initiative in January of 2022, he mentioned, the Honorable Prime Minister, that we can make a severe dent in white-collar crime in Trinidad and Tobago if we implement certain strategies as it relates to digital transformation. So I could only quote from the Honorable Prime Minister, really.
But Madam Chair, we are not at loggerheads here. We are, through you, we are at the same point, but I guess the short answer is no. And you are talking about digital transformation. Madam Chair, I want to compare oranges with oranges. My next question to you, sir, is this. Having agreed that at least the government of Trinidad and Tobago did its part by passing the legislation through both houses, you agree that that part was done, correct?
Through you, Chair, that is in the public record that the government would have done the necessary requirements.
With these red flags that have been raised by serious stakeholders, don't you think, sir, that it is more sagacious and prudent to address these red flags before rushing into proclamation? Don't you think so?
Again, through you, Chair, I would have answered that question in that we would have responded to the Attorney General, and we are awaiting response from the Attorney General on our recommendations.
No, but Madam Chair.
Mr. Scotland, I know you're on a roll, and perhaps I may advise you, because you have certain concerns, that you could look at some of the reports of Transparency International. You look at the corruption index and those papers that go along with it. I myself will be able to assist you with some of the reports that came out.
I have some before me, Madam Chair.
Oh, you do. But you were asking, and you because implicit in his answer, even before you went to the fourth and fifth and the sixth question, is that he didn't have the statistics. He didn't have them.
Madam Chair, I have moved on from the statistics. My question to the learned chairman of the procurement regulation is office of the procurement regulation is this. If he does not think, as the person who heads the organization, that it is more prudent at this stage, more sagacious, to deal with the concerns raised by the red flag, his answer to me is, I have made recommendations. That is not my question. Don't you think that it is more prudent to deal with the red flags that have been raised before we rush into proclamation? Madam Chair, that is my respectful question to the Office of the Procurement Regulation.
Chair, again, I reiterate that we were requested by the Attorney General to respond to the letter from the Chief Justice. In terms of our response, we would have adequately covered those areas of concern that the Attorney General would have raised, and we are awaiting response from the Attorney General in terms of the same red flags.
Madam Chair,
all right, we're moving on now, please.
Yes, Madam Chair.
Madam Chair, I don't wish to take, and unless you will give me a second bite of the cherry, Madam Chair, I give way to you and your conduct of the meeting, but I am here. I do have some other issues, but I want to give other members a chance.
That's so nice of you, Mr. Scotland. I do appreciate.
Yes, Madam Chair, if I may, through you, I am looking at a document that the AGLA produced in response to issues raised by the judiciary. And it has to do, and this is not me speaking, this is the judiciary speaking. So if Mr. Lauchang could address the issue, the judiciary raised the issue of the real potential of the act to frustrate and hinder the functioning of the courts and other public bodies. This is the judiciary speaking. And the AGLA's response is this, and the public needs to hear it. The judiciary to propose amendments to cater for the day-to-day and low-cost or ad hoc procurement and the operationalization of some of these clauses if they run a real chance of hindering and frustrating the functioning of the judiciary and probably most public bodies. How do we intend to proclaim this piece of legislation when the judiciary, and these are my layman's terms now, is talking about the separation of powers and the OPR frustrating the work of the judiciary. So what is encapsulated here are two things: separation of powers, because the judiciary raised the real issue in item number 2. There seems to be no separation of powers, and the legislation is enabling the OPR to conduct hearings and investigations. That is why I asked about the evidence. So the whole issue is, one, is Mr. Lalchan comfortable that the judiciary may be incorrect, that their power as an independent arm is not being curtailed? And two, has he received the amendments from the AG as proposed by the judiciary to cater for day-to-day and low-cost or ad hoc procurements? Because what is being circulated is that the Procurement Act and its regulations make no distinction between purchasing a rubber band or building a highway. So could Mr. Lalchan respond, please?
Thank you very much, member, and through you, Chair. That's a very good question. And we are very mindful that in all our training sessions, to deal with those level of activity in terms of how you categorize those activities in our handbooks and guidelines. So we deal with high risk, high value contracts. And then you deal with low risk, low value. And there is, under the methods and procedures of procurement activities as passed in the upper and lower house in January and February of this year, detailed information in the regulations as how you deal with those things. And it deals with from single source, sole source, three codes, and the whole issue of dealing with purchasing a rubber band as opposed to building a highway. And it's not really true to say that you go through the same process, because what you're trying to do is fulfill the objects of the Act under Section 5. And therefore, it gives you opportunity in your handbooks and guidelines that supplements the Act and the regulations to determine how you go about procuring these small items as opposed to the big items. You're not going to spend the same time and level of complexity to build a highway than you would in buying a rubber band or a wheelbarrow or anything like that. So the issue is one that the public body has within its control, how you go about procuring that and keeping it in line with the Act and regulations. So you don't have to take, as I normally say, a sledgehammer to kill a biting ants. The law provides for how you do about these small ones. And for example, if you have to purchase water or stationery and office supplies on a regular basis, what we find happening is that a number of public bodies go back to the three-code system on a monthly basis and procure these activities. Why not enter into a framework agreement where you set the pricing structure for the next 1 to 3 years so that you have call-out notes? So all those things are provided under the Act in terms of how you do small procurement as opposed to large procurement.
Chair, through you, I am grateful that Mr. Lalchan is putting these things on the records, but the judiciary's responses that the judiciary needs to propose amendments to cater for day-to-day and low-cost or ad hoc procurement. What Mr. Lalchan is saying, this can be done on another more informal level, but the judiciary wants amendments. And this is where I'm having a bit of difficulty rationalizing what the judiciary is saying versus what the OPR is saying. Through you, Madam Chair.
You know, I've heard the arguments, I've heard the concerns, and really some of these can be posed to the Attorney General when he appears before us. I think what Mr. Lalchan is trying to say that there is a balance that is struck between de minimis, things that are of very minimal value, and big contracts. And the question of separation of powers does not signal to me that there is no oversight. And what needs to be done is for the examination of how both sides' concerns can be addressed. And I don't think we can go much further in this meeting on this point. We have other matters that we would wish to deal with. So maybe when the Attorney General comes on the next occasion, as we said earlier, he will be appearing with his team. We could deal more with this area, which is of some concern.
Thank you.
Chair, can I make a statement before you move on to other questions? Chair, I just want to, I've been listening to Mr. Lalchan and my colleagues. They're very robust, and relevant questions being raised with respect to, especially with respect to the comments by the judiciary on the public procurement legislation that was passed by the Parliament. Now, Mr. Lalchan and his team are creatures of this very important piece of legislation. It appears to me that Mr. Lalchan and his team, whilst embarking upon the journey of implementing the legislation and preparing state bodies for the full proclamation of the legislation, that some of the gray areas and areas in the legislation that may not be necessarily clear, it now falls to them to provide clarification and or guidance, to provide guidance to public bodies. And I think the comments by the judiciary, the recent comments by the judiciary, would have caused Mr. Lalchan and his team, and all of us as a matter of fact, to really pause and give deep reflections to the very, very serious concerns raised by the Honorable Chief Justice and the judiciary. I don't want to belabor some of the other points raised by the judiciary. However, it appears to me that if we are not careful in the way we move forward with this piece of legislation, it can cause some serious challenges for us as a country, especially with respect to public bodies delivering very, very important services to the country, like, for example, our health institutions, ministries that are responsible for dealing with emergencies, road repairs, landslips all over the country, even water and electricity, and having to deal with issues. Because at the end of the day, it appears that the legislation would have given widespread this discretion to the Office of Procurement Regulation. And whilst Mr. Lalchan and they may be a bit discreet or, how should I say, balanced in the way that they may interpret the legislation, it bothers me that someone else sitting in that chair can interpret some of these gray areas quite differently, resulting in serious issues and impacting upon public bodies' ability to deliver important public services to the people of Trinidad and Tobago. I just thought that I should put that on record, having listened to some of the comments, the issues raised by the judiciary in writing, and some of the responses being provided by Mr. Lalchan and his team.
Excellent point, well taken. Member Scotland?
Madam Chair, there is one issue through you that it's a very telling jurisprudential concern, Madam Chair. Madam Chair, the issue raised by the judiciary relative to the minimal adherence to the principle of separation of powers. Madam Chair, you would recall in another capacity, Madam Chair, the case of Hines and the Queen. And I'm wondering through you, Madam Chair, if we can signal to the procurement body that this presents a serious potential bugbear if the legislation is proclaimed in its current form. And there's a challenge, Madam Chair, in sibling to what was done in Hines and the Queen. Madam Chair, you remember that famous case and Lord Diplock. And it may very well come to naught, Madam Chair. I don't know, Madam Chair, you are much more seasoned in that branch of law. I don't know if maybe you can communicate that to Mr. La, just for him to understand that that's a potential challenge and a potential bugbear going forward, unless it's dealt with beforehand, Madam Chair, through you.
Mrs. Members, as I said before, these are serious concerns. We have taken an unprecedented step to invite the Attorney General. We've never invited, as you said before, any minister to come before us with his full consent. On the next occasion, I think it would be extremely important to have the input of the person who advises the government on the law. So to put Mr. Lalchan in the position now where he has to respond to these type of questions, I do not think it is right. I do not think it is fair to him. I think we need to hear from the Attorney General and the team to answer these concerns in greater depth that have been raised by the judiciary.
Madam Chair, your every word commands my obedience, but it is something that is on record, Madam Chair, and on the next occasion, we will have to interrogate it as a committee, Madam Chair.
I thank you so much for your understanding, Mr. Scotland. May we proceed?
Yes, Madam Chair, I do have one practical question, if I could pose it through you to Mr. Lalchan. And Mr. Lalchan, I don't want you to get the impression you're under attack. We are just in the process of examining a serious piece of legislation that we all want, but we have to make sure that whatever we operationalize is fit for purpose and suits the interest of all of us. So I think we are not working here at cross purposes. So I don't want you to leave here feeling that you are under attack. You are not. We just wanted the same thing by having a serious examination. In one of your earlier submissions, you raised the issue of plumbers and carpenters being on your registry and so on. And I raised the issue of what is a public body and what is public money. I'm going to give you a practical example. The Ministry of Health gives a $750,000 subvention, I believe, I think that's the amount, $200,000, to an organization called Horses Helping Humans, where autistic children interact with the animals and so on. So that's a public body receiving public money, considerable amount. And you had mentioned that most of these monies go towards paying staff, and I countered that by saying, not really. If Horses Helping Humans, which are used as part of the therapy for autistic children, receiving public money, and they are a public body under the Act, and they want to hire, let's say, a carpenter, a mason, and a plumber to build a trough for these horses. If they are registered with you as a public body receiving public money, and you mentioned about the part that plumbers and so on could register, are they bound to only hire a plumber, a carpenter that is in your registry, as you said, who must be VAT certified, have a BIR number, NIS number, or they are free to engage any carpenter, any plumber to build a little trough for their horses? This is just a practical example that the public should be aware of.
Thank you very much, member. And through you, Chair, again, an absolutely great question. And the answer is simply, I could go into detail, but the answer is yes, because now under regulations that was passed and in the resolution that was passed in the Parliament in January and February of this year, it specifically says under Section A of that particular regulation, if procuring entity shall only invite suppliers or contractors who are pre-qualified in the procurement depository to participate in procurement proceedings. And that was this year passed in the Houses of Representatives and the Senate.
So Mr. Larchan, and through you, Madam Chair, and this is important, we are putting in the public record that an NGO helping autistic children as a public body receiving public money can only deal with a plumber, a carpenter, or a mason who is on the registry of the OPR. I am glad that Mr. Larchan has put that in the public domain, because I can see so many problems coming in to that. Thank you, sir. Thank you.
You're most welcome.
So, Madam Chair, can I don't know if I got it clearly, but Mr. Larson, are you confirming as accurate what Member Terence Diasing has just indicated?
Through you, Chair, as I would have mentioned, member, that is enshrined in the regulations that was passed, that you can only use pre-qualified suppliers and contractors on the database. So if you are going to engage in good services for any contractor and supplier, you want to make sure that they are registered. In fact, and we congratulate the Water and Sewage Authority for sending out a public advertisement to indicate to all their suppliers and contractors, and that's the very first public body that did it, that they should come on the OPR's website and be pre-qualified because they understand what are the requirements now. So the answer is absolutely yes.
Would you say, Mr. Larchan, that this particular requirement is because you want to protect the public so that they have people who are competent to carry out the job? Because many people have come to grief by people who they pay and they just do not do the job, or are unable to do what they're required to do. Would you say that that was the rationale for having this?
And that's correct, Chair. And it is required under Section 29 of the Act that speaks to the whole issue of financial capability, competencies, and so on. Make sure they have all the necessary tools and requisites, equipment. They are not insolvent, they are not in bankruptcy, and so on. Because sometimes you go out and you award contract and you have upfront payments taking place. And sometimes it's difficult because some of the contractors walk away with your money and you can't recover it because you can't find them. So those are some of the safeguards that have been put in the legislation for just such a time like that. So you're quite right, Chair.
Oh, I know some cases, Mr. Larchan. I do. Thank you so very much for, you've been very helpful as far as you could be, because you don't have everything within your grasp. But we need to go on to the Ministry of Finance, and we would hate to be losing people who have to have lunch or have to be elsewhere. So I would invite questioning from the Ministry of Finance. We have a lot more questions for you, but I'm afraid we did go into some areas that were very, very prolonged. So we would have to leave you now and thank you for all that you've tried to do as we go to the Ministry of Finance, who I'm sure they're wondering why they've been sitting here for so long. Now, we're looking at objective 2, to examine the factors and circumstances that are hindering the successful implementation of the Act. And in the submission of the Ministry of Finance, what was stated as the main external factors that are hindering the implementation of the public procurement regime are concerns raised by the judiciary again, which are being reviewed by the AG. What preparatory steps have been undertaken by the Ministry of Finance at the organizational level in anticipation for the full proclamation of the Act? This is to the Ministry of Finance.
Chairman, I believe that whatever was required of the Ministry of Finance to have been done has been done. And we are waiting the proclamation. Of course, we have the issue now where the Attorney General would have to guide the government on the issues raised by the judiciary. But we have done what we were required to do.
My specific question was, what preparatory steps have been undertaken by the Ministry of Finance at the organizational level in anticipation for the full proclamation? What has been happening with you? I'm quoting your submission, you know, and I'm asking you.
Yeah, sorry, we had some little challenges there to unmute our mic. We have been engaging the Office of the Procurement Regulation. We have been working closely with the OPR to, you know, with regard to the regulations and and so on. The state enterprises that are under the purview of the Investment Division, Ministry of Finance, we have been indicating to them to ensure that their procurement procedures are in compliance with the Act. And as Mr. Lachan had indicated, a lot of state entities and ministries have reached out to the OPR, you know, to review their procurement procedures and guidelines. And also under our purview, of course, well, the Ministry of Finance would have provided the necessary funding for the operations of the OPR. And as you would have seen in our submission for the 2023 budgetary allocation, there was a substantial increase of about 40% from the previous year.
If I may ask you to condescend to particulars, you in your submission, page 3, to question 1, you stated that the main external factors that are hindering the implementation of the public procurement regime are concerns raised by the judiciary, which are being reviewed by the AG. And our question to you is, what preparatory steps have been undertaken by you? Have you set up a department to deal with procurement? What have you been doing while waiting?
Okay, Chair, I'm just asking if it is what the Ministry of Finance as a ministry is doing, or what the Ministry of Finance has been doing to prepare other ministries and departments and state entities. Because I think the Office of the Procurement Regulation and the regulator, they have provided extensive guidelines and guidance to these bodies. And of course, we want to ensure that we do not encroach on their operations as prescribed in the law.
The Ministry of Finance holds the purse strings, yes?
Yes.
What have you been, you know that this is coming, the proclamation. Have you been doing anything really to assist so that when you're ready to operationalize, you know, that the other entities that you have been funding, anybody, I don't want to put words into your mouth, but I know that you're not sitting back just waiting for it to happen. So that's why I wanted to know, have you established a procurement unit? You know, what have you done?
Well, each ministry is supposed to have their own procurement unit. They're supposed to have their own the named procurement officer and supposed to communicate that to the OPR. So the accounting officers at ministries and departments, they according to the Act, have that responsibility. Of course, any guidance that is required, they can reach out to the Ministry of Finance in that regard.
I'm getting a sense that nobody has reached out to you and, you know, you're just waiting for something to happen rather than being proactive.
Chair, I'm getting the sense that you're alluding to the fact that the Ministry of Finance has to have a procurement unit that governs the entire public service.
No, you have your unit. Other people,
yes,
you know, will have to be funded as well by you.
Yes.
Yes. So has that been happening?
Yes. So based on what our budget division would have indicated, the ministries, certain ministries would have requested funding with regard to establishing procurement units. And based on our submissions for the 2022-2023 budget, the figure stood at 11.5 million. What was requested was around 22 million, but what was allocated was 11.5 million. So from a budgetary standpoint, we have provided the requisite budgetary allocation. From an operational standpoint, we would be guided, of course, by the OPR. And with regard to training, we have the Ministry of Public Administration who once training is required, we can reach out to the MPA to provide the requisite training, of course, under the watchful eye of the OPR.
Thank you. Now, you stated that the Central Audit Committee of the Ministry of Finance reviews procurement procedures of state entities and makes the requisite recommendations for alignment with the Act. How many state enterprises have been reviewed by the Central Audit Committee to determine whether their policies and procedures are in alignment with the Act?
Chair, the Central, just to give you a history, the Central Audit Committee was established in the early 1990s when it was felt that there needed to be oversight over the procurement of goods and services by the state entities. So since then, the Central Audit Committee has been engaged in reviewing the awards of contracts at these state entities. And in reviewing the awards of contracts, they would sometimes request that the evaluation reports and so that were done should be submitted for their review. When they review evaluation reports and they look at the controls, and they determine that the controls are weak and the procedures are not in accordance with best practice. And now we have the law and the regulations. They would make recommendations, accordingly. But to say that, all the state enterprises were reviewed by the Central Audit Committee, I can't state that. But in the course of their operations, this is what they do. Yes.
So I take it that you are unable to say how many state enterprises have been reviewed. Have any been?
I'm not able to say.
Have any been at all?
Yes, I believe so, but I can provide that information in writing. Yes. And I would say it would be the larger state enterprises.
Thank you.
Chair, can I ask a follow-up question?
Yes, please.
Chair, through you to the officers at the Ministry of Finance. Has there been a committee being chaired by the Ministry of Finance comprising other state agencies that has been charged with the responsibility to ensure that state enterprises and other public sector bodies would have put everything in place to become compliant with this piece of legislation?
Through you, member, no, I don't believe so.
Thank you, Chair.
Yes. Somebody had a question?
So, Chair, I am getting the impression that it was left up to the Office of Procurement Regulation to ensure that state enterprises, ministries, etc., would have put all the necessary resources and programs in place to ensure that they have become compliant, or that they become compliant with the piece of legislation. However, I was of the view that the Ministry of Finance and its officers, leading a team of technocrats in the public sector, that they would have been taking the lead to work with other state agencies and ministries to ensure their compliance with the legislation.
Yes, Ministry, will you respond, please?
Sorry, Chair. As I said, there is no committee, but I believe that we would consider, given the concerns of the member, and we would look into forming that sort of committee. But of course, we just have to be guided by the Act to determine what is within our remits.
Now, the Office of Procurement Regulator stated that no central tenders board staff has exercised the option to transition to the Office of Procurement Regulator. What is the reason for the lack of interest by the central tenders board staff? You have any idea?
I can't say, Chair. I can't say. I have not had any feedback from any one of them, indicating the reason why they have not opted. They are career public servants, and I really don't want to propose any response, and I don't have their feedback.
I see. Member Scotland?
Madam Chair, through you, may I ask what has been the synthesis between the Ministry of Finance and, let us say, the Office of Procurement in terms of the process of implementing the proposed legislation? Is there any synthesis, any meetings, any collaborative efforts? Through you, Madam Chair.
Yeah, Chair, I'd ask Mr. Suhan to respond, please.
Chair, through you, the Ministry of Finance, especially in relation to the last 10 regulations that were passed this year, has worked quite closely and assiduously with the OPR in ensuring that concerns with respect to the way the legislation was prepared, had been captured and as required by law to factor in the concerns of the OPR before moving to Parliament. Further to that, there was a transitional committee established between the OPR and the Ministry of Finance to address some of the transitional periods mentioned in the Act. For example, under Section 64 of the Act, the OPR, we understand, would be taken over some of the Central Tender Board, procurements that had not been completed. So the Ministry of Finance, in conjunction with the OPR, had established and continue to have dialogue in relation to transition, in relation to a lot of those matters. As is the public record, because of the intervention of judiciary, a lot of these things have now focused, and the highlight has now been to be, capturing the concerns raised, and the Ministry of Finance is taking the advice of the Honorable Attorney General in relation to those matters in order to determine how best we can proceed, because the ministry is not aware if or what amendments are required in law. It may be that some of these things that we plan for currently may have a different dimension once the dialogue and discussions have been completed and the appropriate amendments, if any, have been identified.
Madam Chair, I am asking this question, therefore, through you in a very neutral form. It has been advanced by another entity before this JSC that the Act should be proclaimed, even in notwithstanding the issues that have been raised by key stakeholders. As the ministry, coming from the Ministry of Finance, do you think that that will be a prudent approach to proclaim the Act, even in light of the concerns raised by significant stakeholders? Through you, Madam Chair.
Chair, through you, the Ministry of Finance is guided by the Honorable Attorney General. The Honorable Minister of Finance has made the position quite clear in relation to questions posed in the House of Representatives, and the response officially is that the ministry will be guided by the Honorable Attorney General on the way forward.
Yeah, and Madam Chair, as my final follow-up question, could you tell us and give us a sense of how many entities have been engaged either by your ministry or you can only speak for your ministry to assess their readiness to receive the Act if and when proclaimed? What is the readiness?
Chair, through you, I know we have not done that sort of analysis because we know that the Office of the Procurement Regulation, they have done it. They have on their website a facility where entities can, assess their readiness. But Ministry of Finance has not done any assessment of that sort.
I am very, very grateful for the answer through you, Madam Chair. Madam Chair, these are my respectful questions.
Madam Chair, just a follow-up to that last question by Member Scotland. Can I ask the Ministry of Finance to state whether or not the Office of Procurement Regulations would have written to the Ministry of Finance indicating the level of readiness by state bodies, public bodies, and ministries with respect to the full operationalization of the legislation?
Chair, through you, I am not aware that we received any correspondence from the OPR indicating such. And just to follow up, I believe some of the statistics, are on their website. So we do have access to some of that information, I believe.
Okay, but is that information critical with respect to any decision being made by or considered by the Ministry of Finance with respect to the proclamation of the legislation?
I believe it is important that all entities are ready. And in that regard, I believe that it would be important for us to have an understanding of the readiness of the entities.
And prudence, through you, Madam Chair, and prudence will dictate the readiness of all stakeholders, state agencies, public bodies, before the Ministry of Finance should consider the full proclamation of the legislation?
Chair, through you, I believe we were not on. No one will be fully prepared because there may be amendments to legislation and so on. Yeah. But by and large, they should be ready for full proclamation.
Thank you, Madam.
You would say that the Ministry of Finance has done all that it could, to assist the Office of Public Procurement.
Yes, Chair. As Mrs. Suwanen indicated, we have collaboration, and also we provide the requisite funding for the OPR to operate. And of course, whatever collaboration is required in future, we are open for that collaboration.
When I read from a source which says, I've confirmed that the Ministry of Finance has made available all necessary financial, technical, and administrative support to the Office of Public Procurement in a timely manner as requested by them. And I wish to compliment the public servants in the Ministry of Finance for their commitment and diligence in this respect. And I hear your hesitation. It doesn't seem to be in sync. And this was a statement I read that in the House of was made in the House of Representatives in February 2019 on the implementation of the Public Procurement and Disposal of Public Property Act, and by the Minister of Finance. So I got a sense that everything was, going very well, and the ministry was on board with it, but I'm getting today a sense of hesitation, and I'm wondering, where is it? Because I've been compiling a dossier before we even decided it, on public procurement for some time now. And I'm wondering where are you really at? This enthusiasm that I'm getting on the one hand, and your hesitation on the other, I am a little perplexed. Forgive me if I should not be, but
if I may,
is there any help? Is there any other assistance that you need? Is there anything that that you would wish to say? Because we're coming to the end, and I won't want to end on this note. I want you to say something that sounds extremely positive in terms of what is happening. And you smile, but I cannot smile. because I think that this has been something, this whole question of public procurement in the public domain for some time. It's a very sensitive issue and it's crucial in governance. It's not just, by the way, it's something that's very crucial, and it affects our economy, it affects our very lives. You heard Senator Dayal speak, I'm not Senator, sorry. You heard the minister speak before about his concerns. So I would hope that at the end of the day, you can give the assurance to members of the public that everybody's on board with procurement because it is so vital. And this is across the board, all the countries, you know, I have several reports from different countries, what is happening. And you just need to get the kinks out of it to proceed, because this is not something that can be delayed and delayed and delayed. Because if things are not remedied and you know things are not right, we know that all is not well. And that's why there's been so much in the public domain about what is happening. We want a sense of fairness and we want our economy to grow. We want the best in education. We want the best in health and all of these things. And we know government can't provide everything. We must use other entities because the expertise, experience don't all lie within the government personnel. So it's very important that we do what we have to do. We can't please everybody, but we must do what is right. This principle of fairness is something that is extremely important. So do you have any closing words for us that will bring us some comfort before we end this inquiry? Who will make a closing statement from the Ministry of Finance before I go to the Office of Procurement? P.S.
Chairman, we have done what we, as I indicated, and as our minister has indicated, we have provided the requisite financial and technical requirements for the operations of the OPR, and we have been doing what is required. We have, as Mr. Suhan indicated, we have provided the technical expertise. We have done everything that has been required, and we are, I believe, on our way to providing whatever assistance is needed for when the legislation is fully proclaimed.
May I now invite the procurement regulator? Sorry. Mr. Lalchan.
Thank you very much, Chair. And again, I want to express our appreciation to the committee for giving us the opportunity to share with the public what's taking place. And in closing, I want to assure the members of the committee that the OPR is committed to this piece of legislation, and we will continue to do what we have to do to make sure that it is proclaimed in the shortest period of time. There is, I might say, based on feedback from the public entity, there is a critical mass that is already on board with this legislation, even though not fully proclaimed. And we will want to encourage more and more public bodies to come on board. And we really appreciate the work. There are some significant contributions that we have gotten from the Trinidad and Tobago Electricity Commission, Heritage Petroleum, Water and Sewerage Authority, and all the ministries. We would have been able to influence some of the major procurement activities during the pandemic. So there is a critical mass, and we will continue to work with all stakeholders to make sure we have the best legislation that we can be proud of and leave a legacy for our children, our grandchildren to come behind us. Thank you very much again.
Thank you very much for your continued enthusiasm. I would like to thank all of the parties who have appeared before us today, and the members, the corporate secretary, the procurement capacity development, head of legal, permanent secretaries, senior state counsel, for coming here today. and for your contribution to today's proceedings. Even though sometimes it may be silent, I know that you would have done, those of you who may not have spoken, you have done your quiet work beforehand and contributed to the papers that you have made, the submissions that you have made in the papers that we have had the benefit of reading. I would wish to thank the committee members who participated remotely in this virtual hearing. Some of us were challenged by the unprecedented backup on the roads this morning. You know, we thought we mightn't have gotten here in time at all. So we thank you for going through that challenge. We thank the staff of the Office of the Parliament for your procedural and logistical support. Always, we are very grateful to you. We thank the viewing and listening audience. We will continue. We will have a next hearing, and we hope that by the next hearing, we'll hear a lot more from the Attorney General's office here and his staff. But as I said in the beginning and in the middle, and I will say again, this is an extremely important act of Parliament, and our very lives and livelihoods, the livelihood depends on getting it right. And I would ask you all to continue to engage with all of the actors to satisfy their concerns, or if you haven't heard from them before, to continue to engage. I know, Mr. Larchan, you said you've met with so many stakeholders, but it's never enough, you know. Sometimes there is this one that you might not have met who will give you an incredible insight, because I see from your demeanor and your words that you are really into this, that you are sincere, and you're trying the very best that you can. So we thank all of you, and we leave you to have your lunch and have a wonderful weekend. And we pray for our country, and we will do wherever we are, always the best that we can do. We've made it not too good for the next generation, but there's still an opportunity while we have life to get it right. It is for them that we work and we do what we do with love in our hearts, and dedication to duty. Thank you.
Thank you very much, Chair. What a beautiful way to end.
Thank you, Chair.
Thank you, Chair.
Thank you for being here and for your wonderful contribution. Wish I could offer you lunch, but next time.